this is a good example of, if Judicial Watch doesn't do it, no one else will, is our successes in California. And I don't know if you've been watching the news or seeing the news, but I hope the news to date, and if not, this is going to be great news for you, is that Judicial Watch obtained a great victory for the rule of law, where a state court judge in California ruled that the California quota mandate requiring a certain number of women to be on boards of directors of corporations was illegal and unconstitutional. This came after a 28-day trial, our legal team deserves so much credit. I mean, one of the wonderful things about Judicial Watch, and one of the pleasures and honors of my job, is to be able to come and communicate and talk about the great work my colleagues are doing. You know, I know you see me on YouTube and on social media and such, and on television, but remember, I'm not a lawyer. I'm not in court for 28 days defending the rule of law, questioning witnesses. It's Judicial Watch lawyers who are doing it. So we had a team of 4 lawyers there 24/7, practically speaking. And if you're a lawyer and you've been involved in a trial, you know how time consuming it is when a trial's in session. As the government lawyers just, did everything they can to put anything they could on the record to try to save their indefensible case, which is that you can't require, and the government can't get in the business of requiring corporations to engage in sex discrimination. The court was having none of it. Her verdict eviscerated this critical theory approach. And there were all these specific all these specific hurdles. The government, in theory, there are possible ways that the government can engage in discrimination that's otherwise prohibited. But it's obviously very narrow. Like, for instance, if someone's been discriminated against, the government can take a position that person should be made whole again. And you could argue, well, that person's benefiting from their race. Well, they were punished because of their race. So that's the sort of really narrow case. You got discriminated against and you're made whole again. And that's not even really racial discrimination promoted by the government. That's just justice, right? But they didn't bother with any of that. And the court saw through it. The law requires, and this is what the law is, it's based on Senate Bill 826. It requires every publicly held corporation headquartered in California to have at least one director who self-identifies. So I don't think we even got into the whole issue of identifying as a woman versus being a female, born female, on its board of directors by December 31st, 2019. So it required at least one by 2019, and also required corporation to have up to 3 such persons on their boards by December 31st, 2021, depending on the size of the board. So the bigger the board, the more women technically they needed to have in order to achieve this quota mandate. Judicial Watch argued that the quota, and we argued on behalf of taxpayers who have the right to challenge illegal expenditure of government funds for illegal purposes like this under California law. And we argued that the quota for women on corporate boards violates the Equal Protection Clause of the California Constitution. And the judge in that case, Maureen Duffy Lewis, Superior Court judge, a veteran judge, agreed and determined that SB 826 violates the Equal Protection Clause of the California Constitution and is thus enjoined. I want you to think about that phrase for a minute, because it's often bandied about. It's obviously an Equal Protection Clause in the California Constitution. The Equal Protection Clause is enshrined in the 14th Amendment. And you have to remember, it seems to me, it's useful to remember that the rights enshrined in these government documents, such as the California Constitution or our federal Constitution, are rights that we have separate and apart from the Constitution. The Constitution recognizes rights we already hold. They're God-given rights, and I mean that literally. They're divine rights. They're divinely given rights. that we have as human beings, children of God, to be treated equally before the law without discrimination, equal protection of the law. And in California, the radical revolutionary left has decided to assault that core constitutional principle, that core human right of equal protection under the law. And if you lose the right of equal protection under the law, and I don't mean it's a violation of the explicit text, I'm just talking about it in principle. If we don't have equal protection under the law, that way lies dictatorship, authoritarianism, totalitarianism, you name it. The government is unchecked and uncontrolled. And the left thinks they can erase that concept of equal protection under the law using this critical theory approach. That there's systemic racism, systemic sexual discrimination, and that certain races or genders need to be raised up because they have specific qualities. It's racism. It's racism, pure and simple. And in this case, sexism. Now, remember, this is the second case that we brought. The other case we brought was another crazy law. And I say crazy, I don't mean to say it's silly. I mean crazy meaning it was so outside our constitutional norms that went beyond the gender requirement for quotas to include include race, ethnic identity, and LGBT status. And in that case, a court that we pursued, and we didn't have a trial on that one, the court said we didn't even go to trial. He could make the decision on the papers and summarily dismissed or summarily affirmed our position that the law was unconstitutional, and also it's also a deadlock. And in this case, the judge issued a 23-page verdict, and I encourage you to read it because it's a scorcher. And she specifically found that the law's goal was to achieve general equity or parity. Its goal was not to boost California's economy, not to improve opportunities for women in the workplace, nor not to protect California taxpayers, public employees, pensions, and retirees. Frankly, none of those goals would have been appropriate to justify rape discrimination. Further, the court found that putting more women on boards demonstrated that the legislator's actual purpose was gender balancing, not remedying discrimination. There's no compelling government interest in remedying discrimination in the board selection process because neither the legislature nor defendant could identify any specific purposeful, intentional, or unlawful discrimination to be remedied. We spent 28 days listening to them make up things as they go along. I mean, that's how I perceived it. And of course, the response of the government to this is, and the leftists who promote it is that, well, it's a shame we can't fix discrimination. The court said you didn't prove discrimination to be fixed. And also the court was offended by their approach. Let me quote you from this part of the ruling. This is one of my favorite parts. The court agreed with Judicial Watch and found that California, quote, had offered the testimony of stereotypical virtues of women, such as consensus builders and, quote, less risky behavior in investments. The court is unpersuaded by this offer of stereotypes for a justification of the law. So that's this is what they were doing. They were insulting the court and the intelligence of everyone who was following this, and of course citizenry, that somehow women bring these special qualities because they're women. That's sexist. It's sexism, according to the left, right? All bets are off when it comes to justifying discrimination by this crowd. And the court found that we had presented persuasive evidence of illegality of activity. So it was unconstitutional and illegal what was going on. So this was a tremendous victory. It comes on the heels of another court decision, as I said. So there's two for two in California in terms of challenging the radical politicians' there's efforts to blow up our laws against anti-discrimination, to blow up our constitutional protections, to blow up our civil rights. And you can bet if we had lost these cases, I hate to think we would have lost, other states would have been out of the gate quickly trying to enforce quota mandates despite discrimination prohibitions in state and federal law to the contrary. This is the second decision finding without a doubt that quotas for corporations are unconstitutional. The radical left's unprecedented attacks on anti-discrimination law suffered another stinging defeat. And what's interesting is I saw a New York Times piece, which of course is a leftist publication. And the New York Times article was, oh, well, you know, it's too bad this law went down, but don't worry, it did its job. It got more women on the boards. Well, how did it do that? Through discrimination. Think about the theory of the case here. If you require that certain slots be reserved for certain people, you're telling other people they can't apply. So if a slot is reserved for an LGBT candidate, a black straight female can't apply. Right? No males can apply unless maybe they're LGBT. And they may be given more weight than the female. It's just crazy town to engage in this type of discrimination. It's so pernicious and so divisive and so dangerous. This racial separatism, this encouragement of racial identity, sex identity, it's so divisive and it's so dangerous because they think the consequences are all positive. And we're seeing in our society every day, this racial division is deadly dangerous, deadly dangerous. In addition to being unconstitutional and illegal. And it blows out of the water the canard that the left is against discrimination. They are the biggest proponents of discrimination in modern American history. This was, for instance, the most blatant attack on our nation's anti-discrimination legal infrastructure in 50 years, 60 years. It would have blown up the 14th Amendment. California Constitution reflects the 14th Amendment understanding. So this is a big deal, guys. This is a big deal. I know we do a lot of work on FOIA to expose government corruption, but here we had the government trying to destroy our social fabric and our constitutional systems that protect our civil rights. Clear and present danger, clear and present danger. And Judicial Watch thwarted it through relentless and proactive court litigation. And I know the courts sometimes don't work the way we want them to work. We sometimes lose, but you only win if you're in court, trying to use them as they're designed to be used to apply and interpret the law in a rational basis, in a rational fashion based on the plain language of the laws at issue and what the law requires, and get a good result. And we did here. So 2 judges in California. Now remember, California is blue, right? And it's all these left-wingers who, no, we can't abandon the rule of law in California just because we think there are a lot of liberals that live there. Look, in Maryland, we won that case against the gerrymandering. Democrat legislature created this outrageously partisan map that denied fair access to Republican or fair representation to Republican or other voters. And a Maryland court judge said that's wrong. She was a Democrat, the judge. And then in New York, Democrats lost there. New York is a big blue state too. And New York said, look what happened in Maryland in Judicial Watch's case. So isn't it remarkable that Judicial Watch has had its most significant successes in at least this year. It's the what have I done for you lately, right? In California and Maryland, two of the blue states in the nation. It's those places where the rule of law probably needs the most protection, right? And where we should try to be most active. And more is coming. We've got more election integrity litigation and more. We're on continued battles exposing this critical theory revolution, this Marxist revolution that has overtaken our federal government, our military, our schools, and our corporate and media culture.
First up is our major victory on behalf of the rule of law and election integrity in Maryland, where we challenged on behalf of voters in Maryland the gerrymandered map of congressional districts created by the Democratic legislature there. We had a trial on our challenge. It was a challenge under the Constitution of Maryland, a Declaration of Rights. And we won. The court just announced today, issued a big ruling here. This is the ruling. 94 pages, memorandum, opinion, and order in the Circuit Court for Anne Arundel County, which is the county out west in Maryland. The trial occurred in Annapolis, Maryland, the state capital. We had experts, the other side experts, the state had experts, and there were two challenges, two groups of challengers, and Judicial Watch represented plaintiffs, including a state delegate in Maryland, Neil Parrott, and voters in every district in Maryland. And there was another set of plaintiffs who also objected. And the court ruled in our favor. It called it an extreme gerrymander that violated the rights of Republicans under the Constitution. So this is the background on the story. So Larry Hogan, who is a Republican governor of Maryland, had a citizens commission draw up a map that the left didn't like and Democrats in the state legislature didn't like. So what happened is they drew up their own map and they passed it in the legislature without any Republican votes. And the map essentially, and I think we'll probably pop up the map during the discussion, you'll see how awful it is. They created a map that essentially would lead to no Republicans being elected in the House of Representatives. And the way you gerrymander maps is you jigger the lines in a way to make sure that there are enough members of people who are likely to vote for candidates of your choice. If you're a Democrat, you do it the Democrat way. If you're a Republican, you do it the Republican way. And to a certain extent, that's okay in our political system. But when you cross the line and abuse the rule of law and destroy any sense of normalcy in the political process, where you've got these maps that go throughout the state and look like dead birds in the middle of the state and connect, for instance, in Western Maryland, one of the key districts is connected by, if you've been around Maryland, you'll know that to get to the Eastern Shore, which is the beaches and that area of Maryland, you have to cross something called the Chesapeake Bay Bridge, which is a tremendous feat of engineering, miles long, and that's how they connect the district in Maryland. I mean, it's like being in another country, practically speaking, the way the districts have been set up from one part of the state to another. A complete abuse, and everyone recognizes it to be a partisan abuse. And the Democrats in the state have decided that no one can allow the challenge that under the state constitution, and we said we are. And what happened was, as I said, the Democrats passed the map. Hogan vetoed it. They overrode the veto, and so the challenge went forward in the court, the state court in Maryland, and we won. The court found. And I'm going to read from the court the decision here. This is the decision. It's well worth reading in toto. I don't know how the court got out a 94-page decision in less than a week, but she managed to get it out. So I'm sure there are a few typos and such in here. One of the key findings of the court, she writes, With regard to Article 7 of the Maryland Declaration of Rights, the plaintiffs, based upon the evidence adduced at trial, prove that the 2021 plan was drawn with partisanship as a predominant intent to the exclusion of traditional redistricting criteria by the party in power, the Democrats, to suppress the voice of Republican voters. The right for all to political participation in congressional elections was violated by the 2021 plan. As a result, this court will enter a declaratory judgment in favor of the plaintiffs, declaring the 2021 plan unconstitutional and permanently enjoining its operation, and giving the General Assembly, which is the legislature, state legislature of Maryland, an opportunity to develop a new congressional plan that is constitutional. A separate declaratory judgment will be entered. So this is just great. And this judge, by the way, she's not a Trump appointee. She's not a Hogan appointee. She's, as far as I can tell, she's a Democrat. She was appointed by Democrats in Maryland, and she saw right through this, that this was an extreme, and she uses the language, extreme gerrymander. And this is one of the worst gerrymanders in the country. And it's very rare that state gerrymanders such as this, or congressional districts such as the congressional district maps such as this, are thrown out. And as best we can tell, certainly in the modern era, I think this is only the 5th time it's happened. And you know, the left likes to make it seem like, oh, only Republicans engage in partisan gerrymandering, or they usually play the race card, which is not true, which is usually not true, and suggests that the Republicans are racist in how they gerrymander as opposed to just being partisan. But here, the Democrats were caught with their hand in the cookie jar. And gerrymandering is, you know, maybe it's a technical term, but one way to think about it is you have the party in power trying to rig elections by improperly, in this case, keeping voters in jurisdictions in a way to guarantee certain politicians will be elected, mainly politicians of the Democrat Party. And as I said before, there's nothing wrong with doing that if you're in power in a modest way. You know, you've got some flexibility, you're keeping the maps compact and relatively distinct in terms of making sure that there's no unlawful, where counties and towns and localities are kind of torn apart for the purposes of redistricting. And you got a little give and take. You keep, you know, some members of your party, you know, you make it work for members of your party. But then there's an abuse, and you see that in the Maryland map. And it was so extreme that this Maryland court judge says you got to go back to the drawing board. So what happens next? It's a little bit unclear. It looks like they have 5 days to appeal, and they could go straight to the Maryland's highest court. We'll see what happens. But I think it's looking good, and this is one of the most notorious partisan gerrymanders in the country, and it's no doubt it doesn't provide fair and effective representation for all citizens, and it violates the Constitution of Maryland. It's now official. There's a court that found that it violated the Constitution of Maryland, and Judicial Watch has been at this game for a long time in terms of trying to get the courts to look at these improper gerrymanders. And to be fair, Republicans do it too. They sometimes engage in abusive partisan gerrymandering. I mean, it's a temptation, especially if the courts are unwilling to police it, as certainly in this case, the state constitution allows them to do. I mean, in Maryland, for instance, Republicans accounted for 35% of congressional votes. But under this map, they wouldn't have been able, practically speaking, to elect any one representative. I mean, how is that appropriate under the Constitution of Maryland? You know, that requires voters to have a fair chance to participate in our election process. So this isn't even a federal constitutional fight. This is the state constitution, which has these broad protections that seem to prohibit this partisan gerrymandering. Indeed, the court suggested and agreed with us on that. And so we've been fighting this for years. Our lead lawyer and our election team, our lead lawyer is Bob Popper. Russ Nobile was on the team, and Eric Lee of our attorney staff as well. They all worked hard on this, so they deserve great congratulations. So the wonderful thing about this, the work I do, at least in these updates, is I get to come on and talk about all the other great work my colleagues here do at Judicial Watch. And of course, our clients came forward and did this, and you know what happens when you challenge the left. They come after you. So we're grateful for our clients coming forward, and Delegate Parrott taking some leadership on this as our client. And as I said, it's not a partisan issue. The Judicial Watch, Bob Popper, who is our lead attorney, he testified, as I told you a few weeks ago, in Florida. Ron DeSantis, his people knew that Popper was an expert on these areas, and he came down and testified against a gerrymandered district that was racist, that took a whole bunch of black voters and stuck them up in North Florida in an obviously gerrymandered map that went across the state, this top of Florida like this, from Tallahassee, I think, all the way to Jacksonville, as I recall. And Bob pointed out that you can't do that. You just can't stick voters in districts based on race in this improper way. And the Republicans wanted to do it. The Democrats wanted to do it. And DeSantis said, no, we're not doing it. So this was a Republican fight. And Judicial Watch took the side of, in our view, the rule of law here, against the Republicans in the Florida legislature. And they didn't like that. You believe me, they didn't like that at all, I can tell you that. This is just great work, and it's just one element of Judicial Watch's significant election integrity efforts on our side of the philosophical divide, which is a divide, frankly, on which 80 to 85% of the American people are on. Judicial Watch is the leader for election integrity. There's no one else out there doing these challenges like Judicial Watch is on gerrymandering, educating legislators, educating Congress, going to court to successfully clean up voter rolls throughout the nation in California, Ohio, Indiana, Florida, Kentucky, Maryland, Illinois, North Carolina, Colorado, Pennsylvania. We could be in Oregon. We could be in New York soon. Plenty of other places who I'm sure I'm forgetting. But the point is, we're cleaning up the rolls. We're defending voter ID in court. We're suing corrupt legislators who are abusing their power to try to rig the game of elections on behalf of their party in a way that punishes their fellow citizens in various states. That's called gerrymandering. No one else does it. No one's doing the kind of the broad work that Judicial Watch is doing like that. And now, there are some great other groups on our side who are doing some of that work. But Judicial Watch is the 900-pound gorilla in this area. And the left knows that, and they hate us. They're targeting us because of it. So you have these Soros operations coming in to try to intervene in our cases. We get harassed by Democrat front groups. We get harassed by the ACLU. We get targeted by the left-wing media. But we are not going to back down when it comes to cleaning elections, to clean elections. We're not going to back down. So more lawsuits to come. We're going to keep on fighting through the appeals process in Maryland. But I tell you, we're going to lose our republic if we don't have clean and fair elections. And the left has decided they do not support clean and fair elections. And so we need to stand against that. And that's what we're doing. So a great victory. And of course, I thanked our lawyers, I thanked our clients, but I want to thank you, our supporters, because we're able to do this work and be in court for fair and clean elections to defend our republic because of supporters like you. And if you're not supporting us, you see what we're able to do with the support we currently get. And I encourage you to join our cause, join our movement, and join Judicial Watch. Well, I have some good news, so I guess I should start smiling, right? We settled a lawsuit with North Carolina to clean up their election rolls because you know why? They cleaned up their election rolls. Judicial Watch is the national leader in making sure that the federal law that requires states to clean up election rolls, take reasonable steps to clean up election rolls, is followed. The Justice Department has been AWOL on that. So Judicial Watch has stepped in and filed historic private lawsuits against states and counties to make sure they're cleaning up their rolls. You may recall that we sued California a few years back and LA County, and they settled with us. And part of the settlement agreement was they were going to take steps to remove up to 1.6 million names from their rolls. We followed up on that litigation with more litigation against Colorado, Pennsylvania, and North Carolina. And just this week, we announced a settlement with North Carolina because they did what we asked. They took reasonable steps to clean up election rolls. In fact, according to the records we examined, they removed 430,000 names from the rolls that shouldn't have been there. Remarkable. And of course, that wasn't done until after we sued. So great news. Our elections are going to be markedly cleaner and less susceptible to fraud because of this cleanup in North Carolina. In June of 2019, so just to be clear, we sued North Carolina, and there were two counties that were terrible down there in terms of having dirty election rolls, Mecklenburg and Guilford County. We sued them back in 2020, so it's about 2 years ago. In June 2019, the U.S. Election Assistance Commission, which is a federal agency, released data showing that voter registration rates in significant proportion of North Carolina's counties were close to or above 100% of their age-eligible citizenry. So when you go, just to take a step back, when you got more people on the rolls that are there than are there and eligible to vote, that's a pretty good indication your rolls are dirty. Judicial Watch's analysis also showed that at the time of the report, the entire state of North Carolina had a registration rate close to 100% of its age-eligible citizenry. So, you know, registration rates are a bit higher than they used to be on average, I think. But, you know, mostly registration rates are around 80%, sometimes 85% at the highest end. When you have registration rates at 100% or higher, there's something wrong. They're not cleaning up their lists. So we warned them. They didn't do what we asked them to do, so we sued under the law. And since then, we received additional data from the Election Assistance Commission showing they finally started doing what we sued them to make them do. The total number of inactive registrations, and this is from our settlement filing with the federal court. The total number of inactive registrations reported by North Carolina dropped from about 1.2 million in 2019 to about 765,000 in 2021, a 36% drop. As I said, 430,000 names. The statewide percentage of inactive registrations dropped from 17% in 2019, which the complaint alleged to be a national outlier, to 10% in 2021, which is close to the median state inactive rate. So the point isn't that you can't have voters on the rolls who are inactive, because there are always going to be voters on the rolls that are inactive. But if the percentage of inactive voters, meaning people who haven't voted more or less in the last two or more election cycles, are so high, it means you're not cleaning the rolls off. If someone hasn't voted in 6 years and otherwise hasn't communicated that they're still around, you really need to be taking their names off the rolls. And that wasn't going on, it looks like. This is another important step. The number of registrations removed for failure to respond to an address confirmation notice and vote in 2 consecutive elections has increased from about 220,000 for the period reported in 2019 to about 590,000 to the period reported in 2021, a 168% increase. So let me explain what goes on there. You don't vote in an election. What's supposed to happen, at least a federal election, is you should be getting a postcard from your local or state election authority asking, hey, you know, you didn't vote, are you still there? And if they don't hear from you, or you otherwise don't vote in the next two federal elections, they are supposed to remove your names from the rolls. So that's like, you know, 4 or 5 years, right? Practically speaking. What's the big whoop about doing that? Well, the left hates the idea that you remove anyone's name from the rolls because, in my view, they want to be able to have extra names on the rolls to mess around with if they need extra improper votes. That's why we're supposed to have clean election rolls. It mitigates the opportunities for fraud. When you have names who are on the rolls who are moved away and shouldn't be there, that is an invitation for fraud. That's why the law requires they be cleaned up. And so after we sued, they went from 220,000 names that they cleaned up to 590,000 names that they cleaned up. Isn't that remarkable? And in the counties, they had a cleanup rate, or the numbers that they cleaned up were increased by 142% in one county and 372% in another county. So that was just great. Now, Judicial Watch isn't like some of these other lawyers out there that will torture you with a lawsuit when there's no good faith basis to do so. And so what happens is we saw that they cleaned up the rolls. And so what we're going to do? Sue forever over their cleanup? So we saw that they did what we asked them to do, where the numbers were what we wanted them to do, and we determined that in good faith that this legal action shouldn't be pursued. So this is what happened. We sued North Carolina because their rolls were dirty. They started to clean them up in a significant way, and so we stopped the lawsuit. Victory. So this is great. Now our lawsuits against Pennsylvania and Colorado continue. They tried to get the case thrown out in Colorado, but they were unable to do so. And in Pennsylvania, our case has changed a little bit since we initially filed it, but we're still pursuing it because there are many counties in Pennsylvania that still have issues. And I've told you previously here that we just sent out warning letters to additional states, 14 counties, I think, in 5 states, alleging that there were well over 12 million names on the rolls that have not really been scrubbed. No, wait, excuse me. There are 12 million total voter registration names. And of those names, only 33 have been removed over the last 4 years under this process that I've been talking about under the National Voter Registration Act. When I say 33 names, there should have been hundreds of thousands of names removed if they were doing their job. I think in all of New York City, which has, I don't know how many millions of, you can just imagine the millions of voter registrations in New York City. I think they removed 10 names. It's a disaster. So we're planning additional lawsuits. So this is a big victory for clean elections. I keep on throwing my press releases away before I'm done with them. So this is a big victory for clean elections. Because dirty election rolls can mean dirty elections. That's why we're doing this work. And now that the left, and with the acquiescence, frankly, of too many Republicans who don't think smartly about this, are greatly expanding vote by mail, it's more important than ever that our election rolls be clean. First up is the ongoing controversy around OBAMAGATE. It's the worst corruption scandal in American history, and the liberal media is desperate to cover it up. The deep state has been desperate to cover it up, but the president is tired of the cover-ups. He tweeted this week that he has authorized the declassification of the OBAMAGATE documents, the Russia scandal documents, and he also said he wants the material on the Hillary Clinton emails out as well. And obviously, we've been pushing the administration on that, and we're grateful to see that. On top of that, we've got the Justice Department currently defending Hillary Clinton in court. In my view, the president needs to fix that. It's just been released just as I speak. Secretary Pompeo said he's going to be looking at Clinton emails and releasing them soon. So this is all thanks in large measure to Judicial Watch and a few others keeping information about the lack of information in the public discussion. And on top of that, we have some key transparency moves by the president's team, namely John Ratcliffe, who's further confirmed by releasing notes by John Brennan detailing that Barack Obama was briefed on the intelligence they had that Hillary Clinton was coming up with these Russia smears in order to distract the American people from her emails. We talk about just a smoking gun. I mean, they had information that the Russians knew, that Hillary Clinton knew it was all a scam. They briefed the president. And matter of fact, they even told the FBI that they needed to investigate it. The CIA did. And it looks like even the CIA was involved in targeting Trump back then, which might have been a violation of law as well. And so rather than act on that, what did they do? They actually worked with someone they knew was likely to be part of this Russia disinformation scheme, someone they thought was a Russian spy who was working for Hillary. So rather than investigate Hillary, they actually worked with her to try to take out Trump. It began in the administration of Barack Obama. It continued into the administration of Donald Trump, and it's been covered up till just now. And I don't know about you, but I'm tired of waiting for Durham. It's being reported today that General Barr is telling folks there'll be no Durham report. Certainly there'll be no prosecutions before the election. And I've been telling you that for some time, that I didn't expect there to be prosecutions. I don't think there's going to be prosecutions after the election. All this new revelations, it ought not to be new to Durham if he's doing his job. All of this should have been known almost immediately upon his appointment in April of 2019. Just think about that. April of 2019. And we've had one plea deal that's partly bungled and no other evidence that there's been a serious look-see of any of the principals involved. In fact, Attorney General Barr went out of his way to say that it's unlikely that he'd be doing anything with Biden or Obama, which evidently includes not even questioning them, despite all the evidence of their personal involvement in the misdeeds targeting Trump. And I say misdeeds, I was telling a reporter earlier that I'm basically a nice guy. So misdeeds is the charitable way of putting it. It was a criminal conspiracy, a seditious criminal conspiracy without comparison in American history, without compare. And the fact that they haven't been questioned about it, that Clinton hasn't been questioned about it. And I know you say, well, maybe they were questioned about it. Maybe it was done in secret. Well, I doubt that's the case. Nothing in my experience in 20 plus years at Judicial Watch tells me they question officials like that in secret. I take Barr at his word that they weren't targeting them or not even questioning them. So if I were the president, this is what I do. I do what he's doing this week. Order full transparency. Don't wait on Durham anymore. And also separately appoint a special counsel. Now that may be for no good, for no effective purpose if he loses the election. But appoint him now, or her. I don't know. Maybe Sidney Powell should be special counsel. Aside from not inside the Justice Department, separate and apart from the Justice Department, separate and apart from the FBI, the CIA, the State Department, the NSA, the Defense Department, all those agencies that conspired against the president. As I said, a malicious, seditious conspiracy. There's new Flynn information coming out that the top echelons of the FBI all knew they had nothing on Flynn. All knew they had nothing on Flynn. They were saying, well, how can we prosecute him for lying about something that was underlying on a topic for which there was no criminal issue? So the meeting he had with Kislyak, or the phone calls he had with Kislyak, the Russian ambassador, were proper and appropriate, and they knew that. And they were accusing him of lying about the meetings when in fact he didn't lie about the meetings, as the evidence otherwise shows. And they talked about the Logan Act being An uphill battle. It's never been used before. Who raised the Logan Act, by the way, the notes show, separately? Joe Biden. I mean, just think about this. Clinton set up this Russia smear, as I've always said, to cover up her misconduct and distract from to make sure that there be no effective follow-up on for the consequences of her potentially criminal misdeeds. And then once President Trump started raising questions about Biden corruption, which is significant, the Burisma China angles, they tried to impeach him. I mean, this is how desperate they are to avoid the prosecutions. They will blow up our country, blow up our constitutional system. By falsely accusing a sitting president of misconduct, trying to put him in jail, knowing it's all false. Because that was the goal. The end goal wasn't just to remove him from office. They were hoping to put him in jail. Just like they were trying to do the Flynn. All to protect Clinton and then Biden. And of course, Obama knew it all too. So it's the iron triangle of criminality, in my view. And I don't say this because I don't want to vote for Biden or whatever. It's like, this is evidence. There's evidence of a massive criminal conspiracy against our constitutional republic. And the Justice Department has done nothing about it, practically speaking. And to the degree anything's happening, it's because of independent groups like Judicial Watch, a few congressmen here and there, a reporter here and there like John Solomon. It's not even the leadership of the House or the Senate, I mean the Republican side, that's pushing this. It's just a member here or there, Senator Johnson or Chuck Grassley, kind of doing it on their own. It's like a ragtag group of patriots out there trying to get the information out for the American people. With zero help and frankly opposition and obstruction from the FBI and the Justice Department. Of course, they're one and the same, practically speaking. Dirty little secret, Ray works for Barr. So all the obstruction that Ray's engaged in, Barr can overrule. He can get it all done. So let's hope the president's transparency initiative goes forward. Let's hope we get more information out. And I think the president should have said, take that next step. It's not perfect. We're not going to get justice quickly here. It's clear. Durham and the DOJ has been blowing smoke in our collective ear for 15, 16, 18 months. And what fools we have been for listening to them. Now, of course, I never really believed it, but I'm just highlighting the general issue out there that they've been trying to keep those of us concerned about this corruption, saying, oh, something big's coming, something's big coming, making it clear it's coming, it's coming, it's coming. And look, it's not coming. What a fail. What a fail. I mean, they've been trying to play us for fools, and I've never bought into it. My colleagues have never bought into it. That's why we've got 70 plus lawsuits on the issues that we're talking about. So we'll see what happens. Thanks for watching. Don't forget to hit that subscribe button and like our video down below.